suas 39 primeiras edições, nosso congresso foi presencial, com grande sucesso. Veio a pandemia. O desafio de realizá-lo à distância mostrou-se uma oportunidade. Aprendemos a tirar partido da internet e repetimos o sucesso. Agora, para nossa imensa alegria, o pior da pandemia parece ter passado. Assim, podemos voltar a nos encontrar. E vamos comemorar isso no maior centro de negócios da América Latina, na cidade de São Paulo. De dura poesia concreta e discreta beleza. Do ano que se comemora o centenário da Semana de Arte Moderna de 1922. Frente a acontecimentos recentes no mundo das artes, como os NFTs, e frente à perspectiva de realidade virtual e a realidade aumentada virem a fundar uma nova internet, certamente teremos muito o que discutir. Como sempre, vamos tratar de todas as novidades no campo da propriedade industrial, pois sabemos que marcas, patentes e desenhos industriais ocupam um lugar de destaque no mundo em transformação. E vamos festejar a possibilidade de voltarmos a nos ver frente a frente. Depois da experiência remota bem-sucedida, quem, por qualquer motivo, não puder estar em São Paulo, não ficará excluído de nosso congresso e poderá interagir com os presentes. Todos poderão assistir a todas as sessões simultâneas no momento que convier, pois o Congresso Internacional da ABPI de 2022 será híbrido, como os novos tempos estão a permitir. E todas as sessões ficarão disponíveis na internet como desejam os nossos associados. É um novo desafio, mas estamos confiantes no sucesso. Afinal, São Paulo sempre foi palco de imensos desafios, da expansão de nosso território à independência, do sucesso de nossa indústria à grande revolução verde que impulsiona o Brasil e da afirmação de nossa cultura e nossas artes. A fronteira agora é no universo virtual e no ambiente de negócios que nele se constrói, totalmente dependente da melhor regulação possível da propriedade intelectual. Se preparem para as discussões instigantes do Congresso Internacional da Propriedade Intelectual da ABPI. Será uma grande confraternização. Não perca!
Good morning, everyone. Welcome to the panel Trade Secret Protection, the International Landscape, and how it could or should influence the Brazilian legal system. This panel is being organized by the International Law Committee of the Brazilian Intellectual Property Association, ABPI, of which Márcio, Merkl, and I are the coordinators. Well, before we officially start with the presentations from our guests, I'll give a brief introduction, very brief, about the idea behind this panel, the reason why we chose this topic, and then I will hand it over to Márcio, who will make a few additional remarks. As we see nowadays, there's a rapid rate of innovation across the global industry. To gain more business, companies need to be smarter and quicker, but also more agile in their approach to innovation. And in this context, trade secrets play a very important role. At the same time, we have been seeing and reading in headlines more and more topics such as global cyber attacks, trade secret theft, and industrial espionage. So over time, the need for its effective protection, for the effective protection of trade secrets, has increased exponentially. And this need and the seriousness of this topic, of this matter, has already been recognized in different countries or jurisdictions. For example, in Europe and in the United States, there are since 2016 two game-changing pieces of legislation, and our guests will address them in detail today. But we also see this movement, or we see changes in other parts of the world, like in Japan, China, and India. In Brazil, in turn, as many of us know, we don't have any specific law about trade secret protection and enforcement, but only two provisions within the chapter of unfair competition in our industrial property law. In short, there is plenty of room for improvement, especially considering the legal and economic importance of this matter. And it's also important to have in mind that our IP law dates back to '96, that is over 35 years now. Well, for all these reasons, we have a lot to learn from the recent international experience or from this international alignment regarding trade secret protection and enforcement. And that is the idea today, to learn a bit about the legislative experience in the United States and in Europe, and to see how the local courts have been applying these two new legislations. In other words, the idea today is to understand how this matter has been addressed at an international level, and how this new international scenario could or should, as our topic says, influence our legal system. And to that end, we have today three very experienced professionals, which will certainly contribute a lot to the discussion of this matter here in Brazil. Well, with this brief introduction, I hand it over to you, Márcio, for your remarks.
Thank you very much, Felipe, for the initial introduction. And also thank you very much for all our speakers who take their time to show a little bit about their experience in the field. This is, as Felipe said, a very important issue here in Brazil. And with the global economy every day more international, this is something that we really have to look very closely so that we can take the opportunity of the ABPI work, who is working towards the renovation or retrofit from our industrial property law. So maybe this is a good opportunity to take the experience from other countries to review the provisions from the Brazilian law. So, and we know that we have really very complex issues here, like how to enforce a trade secret in the courts, as normally courts are public. So how we can enforce this? This is actually one of the questions that we are dealing now in the in some of our committees here in the ABPI, because in San Francisco later this year, we in the International Association of Intellectual Property, ABPI, this is one of the questions, how to enforce this in the courts and preserve the confidentiality of the trade secret. So we are very eager to hear all of our speakers today. And so we will start with Mr. Axel Oldekop and Mr. Daniel Hoppe, which they are from Germany. They are in Munich now, I think so. And so Mr. Daniel Hoppe, he studied at the University of Leipzig, was a judge at the Administrative Court of Leipzig as well, a public prosecutor in Leipzig, and since 2008 he moved to private practice as an attorney at law in firms like White Case and Hart Davidson, and now he's an attorney at law at Pro Bowling in Hamburg, and his main practice areas are patent law, employee invention law, and trade secret protection law. And we have also together with us today Dr. Axel Oldekop. He also studied at the University of Constance in Madrid, and in Madrid, Spain at Complutense. He holds a doctorate at the University of Osnabrück, and since 2004, he's an attorney at law in patent and law firm in Constance, and since 2006, he's an attorney at law also at Grondzik in Munich. And his main practice areas are patent law, trademark law, and trade secret and protection law. And also, it's very important to note that they both have written a book, which is also actually a very important handbook of intellectual property, of protection of trade secrets. I think that just published the second edition in 2022 now. It's Geschäftsgeheimnisse, Trade Secrets. It was published by Karl Heimann Verlag and Wolters Kluwer, I believe. Correct me if I'm wrong later, please. And also later, to show the view from the US law, we have Mr. Rayan Grondzik. I think I pronounced correctly. And he studied economics at Saginaw Law Valley State University and law at the University of Michigan. And since 2011, he's an associate and partner with Warner Norcross Youth, specializing in employment law, complex commercial litigation, and product liability matters. So thank you very much for the presentations and for your availability to speak in our panel. And I will leave the floor now for Mr. Axel and Mr. Daniel. Thank you very much.
Well, Márcio, thank you very much for your kind words and your introduction. Just short information, our handbook is the second edition is on preparation, and will be published soon, we hope. But yeah, thanks for mentioning that, and thank you very much for having us. So in order to start, would be lovely if you could
Yes, Maria,
set up our slides of our presentation. Yeah. Yes, thank you. And maybe you go to the overview of the topics. One more. Yeah, thanks. So yeah. Okay, yeah, again, thank you very much for having us. My colleague, Daniel Hoppe, who is actually in Hamburg at present, and I'm here in Munich, say good morning to Sao Paulo. So we have been asked by Felipe and by Márcio to contribute to today's seminar with a presentation on trade secret protection and in Europe, and especially in Germany. We are very happy to respond to that call and honored to have the opportunity to give an overview on the legal developments in this field of law in the European Union to the ABPI. Given the time frame we have today and the fact that Daniel and I are German lawyers, we ask for your understanding that we explain the substantive and procedural protection of trade secrets in Europe by the example of Germany, since the current German law actually on the protection of trade secrets is the result of the implementation of a European directive. So please go to the next slide. Could you go to the next slide?
Maria Fernanda, você pode mudar o...
Thank you. So there has been some movement in the area of trade secret protection in the European Union over roughly the last 10 years. The EU recognized, on the one hand, that considerable economic and legal importance, or the considerable economic and legal importance of trade secrets, and on the other hand, the need to harmonize the legal framework for the protection of know-how in Europe. In a study assigned by the EU Commission in 2013, the fragmented trade secrets protection throughout the European Union was identified as a point of weakness for the European industry. This fragmentation was found to be the result of lack of a uniform definition, above all, a uniform definition of what is a trade secret, and lack of harmonized legal protection in the European Union. In Germany, the protection of trade and business secrets was regulated as a special crime law in the Acts Against Unfair Competition, similar to the situation in Brazil, maybe. These criminal law norms could then be basis for civil claims. Due to this link to criminal norms, however, the requirements for protection under civil law were comparatively high and not very flexible. So as a result of the European-wide discussions, the European Union Directive number 2016-943 on the protection of undisclosed know-how and business information against their unlawful acquisition, use, and disclosure was passed and came into force on July 5th, 2016. The EU member states had a 2-year period to incorporate the directive into national law, which expired on June 9th, 2018. The directive aims to ensure a sufficient and consistent level of civil redress in the internal market in the event of a trade secret infringement. Notwithstanding, the directive allows member states to provide for more far-reaching protection, as long as the safeguards which are explicitly provided in the directive for protecting interests of third parties are respected as well. At any rate, the member states must not go below the level of protection of the directive. In other words, we have now a common minimum standard, if you will, of trade secret protection in the member states of the European Union. It would certainly take too long to explain the content of the directive in detail today. However, Daniel and I will touch some of the most important provisions when presenting the new German Act on protection of trade secrets. So please, the next slide. Could you go on? Could you go to the next slide, please? Thank you. To implement the requirements of the directive, the German legislator decided to create a separate standalone codification, which is no longer part of the Act against unfair competition. The new German law entered into force with a slight delay of almost 1 year on April 26, 2019. Let us first take a look at the requirements of the German Trade Secret Act for a piece of information to be protected as a trade secret. According to section 2, number 1, German Trade Secrets Act, information is protected as a secret if the following conditions are met. First, the information must be secret. That is, it must not be known or readily accessible, either as a whole or in the precise arrangement and composition of its components. However, the information does not have to be accessible to the general public. If the circle of people who usually deal with this information know it or can easily access it, it will not be secret. Second, the information must be of economic value. This is the case where its acquisition, use, or disclosure without the consent of the holder adversely affects his scientific or technical potential, commercial or financial interests, strategic positions, or competitiveness, etc. Third prong, the information must be the subject of appropriate confidentiality measures. We will get to this in more detail. And there must be on the fourth prong, there must be a legitimate interest in maintaining the confidentiality of the information. So the new law protects information in the broadest sense. This includes, for instance, technical know-how and business information such as customer lists, business plans, etc. With the requirement of appropriate secrecy measures, the law has created a new objective criterion, which is a significant game changer in Germany. Under the former German law, it was sufficient if there was an objective interest in secrecy and a subjective will to maintain secrecy. The interest in secrecy was in most cases automatically deduced by the courts from the mere nature of the information in question. Also, the subjective interest in secrecy was assumed very generously, so that as a result, almost any information I'm sorry, that was objectively a secret received protection. The new law now requires proof of specific confidentiality measures. These measures must be appropriate in each individual case. If it's not possible to prove that such measures have been taken and maintained, there is no protection as a trade secret. Even information already protected under the old law loses its protection if no or only inadequate confidentiality measures are implemented. This, in almost all cases yet decided, begs the question, what is a suitable confidentiality measure and when is the measure appropriate? Next slide. Could you go to the next slide, please? Thank you. The required secrecy measures fulfill different functions. They should assign the information to a specific person or serve as evidence. However, the main purpose of secrecy measures is to warn third parties that a specific information should be protected and not be accessible to unauthorized individuals. Whether a measure is suitable for keeping the information secret depends primarily on whether it fulfills this warning function. The first available court decisions in Germany on this requirement make it clear that the courts do not require absolute and insurmountable protection of the information. However, the courts have been quite strict in examining the appropriate confidentiality measures. The minimum requirement is that the circle of persons that have access to the information be limited, the need to know principle that you probably know. Depending on the importance of the information, additional measures are required to achieve an adequate level of protection. Tolerating information leaks, on the other hand, can lead to the loss of an originally adequate level of protection. The German Trade Secret Act does not provide for a transition period from the old to the new law. Therefore, in principle, the appropriate secrecy measures must be in place from the date of entry into force, which was on April 26, 2019. However, we have seen individual court decisions which have also based their assessment of the adequacy of the secrecy measures on whether a sufficient level of protection was already in place before the new law came into force, or whether data leaks were tolerated in the period before April 26, 2019. The fourth prong, the legitimate interest, is still in question. At present, the meaning is still unresolved. This additional requirement, which is neither contained in Article 39, paragraph 2 of the TRIPS agreement, nor in the Trade Secrets Directive of the EU, has been included into the new law, literally at the last second of the German legislative process. According to the jurisdiction under the old law, a legitimate interest in secrecy was already affirmed if the information was secret, objectively secret, and its disclosure would have had a negative impact on the competitive composition of the company. Daniel and I, we believe that this should also apply under the new legal situation, so that nothing changes here. Please, to the next slide. So let's have
just 1 second, Axel, Maria Fernanda. Nós estamos com uma linha preta, aparentemente, aqui no topo dos slides. Se você conseguir eliminá-las, por favor. Tá bom? Obrigado. Sorry, Axel, we have a black line here on the top of the slide, so I'm trying to make it removed, but you can move on. Sorry.
Okay, no problem. But this is simply this is also the only the headline I see, I guess.
Yeah.
So it doesn't really matter. Okay, let's have a look at another important game changer for the new German law. That is in Article 3, German Trade Secrets Act. There, the the code lists cases in which the obtainment, use, and disclosure of a secret is permitted, and which limits the prohibitions of Section 4. New for German law is the entitlement for anyone to obtain a secret by reverse engineering, something which is well known to the US colleagues, I assume. But for Germany, it's quite new and a game changer. That means that it's allowed to analyze a product which is freely available on the market. So far in Germany, under the old law, it has been a violation of competition law if the analysis required a significant amount of time, effort, and or expenses to uncover the secret. So now observing, investigating, dismantling, or testing is permitted. The requirements are that either the product has been made publicly available or is in the legal possession of the analysts, and no prohibition to reverse engineering exists. So the second alternative concerns cases where the products or items that have undergone reverse engineering have not been made publicly available, but have been given deliberately by the trade secret holder to, for example, a contractor. In such a case, reverse engineering can be restricted by way of contract or even by law. Such a prohibition of reverse engineering will be possible in individual supply contracts. This should be considered on the part of the owner of the secret in all future contracts, we believe, in particular in research and development contracts, supply contracts, distribution contracts, etc. Where possible, existing contracts should be reviewed and supplemented. And having said this, I would pass over the baton to Daniel and ask you to switch to the next slide, please.
Okay, thanks. So, well, basically the next slide is closely related to what Axel just said. He was talking about reverse engineering, and I would like to present a lot of case law to you, but unfortunately, there is not really, well, under the new law, the questions on matters of lawful and unlawful acquisition of trade secrets has not really been in the focus. So there's not really very interesting case law about this. Still, there is some interesting changes. As said, one of the changes Axel just mentioned, that's the reverse engineering. And in practice, it means two things in practice. First of all, it means that the very fact that something can be reverse engineered or that information can be obtained by reverse engineering does not mean that the information is not a trade secret. So that's the first point. The second point in practice is that we often hear a defendant say, well, I reverse engineered that, I could have reverse engineered it, or this can be reverse engineered by anyone. And that's really a common defensive argument now, and that's certainly one of the changes, well, as a consequence of the change in the law, which affected practical enforcement of trade secrets. In practice, it never really works. That's my impression. It never really works because reverse engineering, it's not that easy in most cases. It takes time and effort and money and so on, and they just don't do it. People who steal trade secrets, they don't do reverse engineering. And that's why usually in court, it doesn't work out for them because they would have to prove that the fact was actually, or the information was actually obtained by way of reverse engineering, and that's where their case usually fails. So going back to the unlawful conducts, they are listed in Section 4 of the German Trade Secrets Act, and it basically makes it a distinction between three types of unlawful conducts. The first is unlawful acquisition, second unlawful use, and then we have unlawful disclosure. One could argue that use is the broader term and encompasses disclosure, and basically in a legal sense it doesn't make much difference. So if we talk about use, it usually encompasses disclosure as well. Unlawful acquisitions, there are two ways to unlawfully acquire a trade secret. The first one is by unauthorized access to the trade secret information itself, or to products which embody it. And the second one is any other behavior, like fraudulent behavior, things like that, by way of which you become aware of the trade secret protected information. Both are forbidden. The distinction is basically made as a, or let me put it this way, there is a criminal law sanction in the law, and the criminal law sanction always needs to be very, very clear. And as you can see, the second aspect, the any other conduct which under the circumstances is considered contrary to honest commercial practices, it's not very clear. It's very difficult to handle in a criminal case. And that's why basically this distinction was made in order to facilitate criminal prosecution. So, well, that's the first thing, unlawful acquisition. The second thing is unlawful use or disclosure, and that always takes place, first of all, if someone uses or discloses information which was unlawfully acquired. That's the first thing. Or if he uses or discloses information and breaches his obligations by doing that. So breaches a non-use obligation or breaches an obligation not to disclose that information. So any of these are unlawful conducts, and these unlawful conducts, they trigger remedies, and we talk about remedies in a second. There's another thing which is new in the law, and you see it on the right-hand side of the slide here. It's about unlawful activities of, well, I call them third parties. And there was a decision of the German Federal Court in the 60s, I think, and that decision was about when can a third party become liable as someone who doesn't know that the information that he obtained from someone else was originally obtained in an unlawful manner. When can that person, that third person, become liable for an infringement of a trade secret? And that was the subject of a decision of the Federal Court in the 60s. And the Federal Court says, yes, it's possible, even if you are in good faith, that you become liable. But no one really knew how to implement that in practice and what it really meant. So now the law is much clearer, even though it's not really very well worded. It says that anyone who obtains information will become liable for trade secret infringement if he continues to use that information, or if he reacquires that information, or if he discloses that information after he has learned that that information comes from an illegal source, basically. That's what the law says. And what does that mean in practice? It means in practice for companies that they have to check whether, if you hire new staff, you have to check which knowledge do they bring in. Is that, how did they acquire it? Because it can happen that they bring in very interesting information to the new employer. Then it's used, and investments are made based on that information. And later on, it turns out, okay, he shouldn't have brought that to our company in the first place. And all the investment is in vain. So that's a very, very important change in the law. It has not been the subject of court decisions so far, but I'm pretty sure it will be soon. So that's about lawful and unlawful activities. And then we can jump to the next slide about remedies and sanctions. Thank you. As said, there are remedies and sanctions, remedies under civil law and sanctions under criminal law. Maybe I should start with the criminal law side of the case or of the matter. So a criminal law is something, well, you can see that it's directed against individuals. It's mainly directed against individuals. So it's not directed against the company. Usually, civil law cases are directed against companies, and criminal law measures against individuals. The sanctions are not very severe in Germany, I have to say. It's like simple theft. If you take the possible sanctions similar to simple theft, if they steal a lipstick in the supermarket, that's basically the same sanction. So that means that there are monetary fines which depend on the income of the culprit, and then there is imprisonment, which really happens very rarely. I'm not even sure it happened before. So it's really very rare. The most important point, and we will talk about this later, is as there is this criminal law angle of a case, a public prosecutor has a reason and has a way to initiate an investigation, which is extremely important in order to collect the necessary evidence for pursuing civil law claims and remedies. So that's why it's not about the amount or the severeness of the criminal law sanctions. It's the very fact that we have them, which allows us to use the public prosecutor to help us in our civil law case. That's the most important thing. Yeah, and under civil law, there are the usual remedies, I would say. So it's very similar to the remedies in intellectual property law. In other fields of intellectual property law, we have injunctive relief and removal, which means that the infringer has to restore the status quo. There is a claim for destruction and surrender of embodiments or objects containing the trade secret. That's a little bit different from other types of intellectual property law, because in those others, it's not about the information. So the destruction claim is about getting back the information which was stolen, or destroying it, if you will. So then there is a call for claim for recall of infringing products and removal from the distribution channels, destruction of infringing products. I'm pretty sure you have similar things in your legal system. Moreover, there is a claim for information. This claim for information is not limited to business information about the amount of sales of infringing products or things like that. It also encompasses information about who gave the information and to whom the information was given afterwards. So that is supposed to put the trade secrets owner in the position to pursue claims and protect the trade secret also against third parties who were somehow involved in the whole thing. Yeah, and finally, there's a claim for damages under Section 10. There's hardly any case law about damages, and it will be interesting to see how to measure damages. In particular, if you think about what's the damage if a trade secret is actually disclosed, and if it becomes public and doesn't have any protection anymore. That's certainly not comparable to measuring trade secrets in patent cases. Also, it's a different kind of calculation. We don't have any case law about this so far. So much about remedies and sanctions. Then I think, Axel, it's back to you again about protection of trade secrets in court proceedings, right? You're on mute. Axel, you're muted.
I'm sorry. Yes, I believe that that it's my take again. Could you please go to the next slide?
I think we have to hurry up a little. So,
yeah, I see. Okay, so I speed up a bit. So another important change in the German law, the procedural confidentiality measures. As you probably know from your own practice, that the plaintiff in trade secret law suits is often in a dilemma. On the one hand, he wants to maintain his information as secret, otherwise he wouldn't have filed a court action against a potential infringer in the first place. On the other hand, he has to show to the court that his trade secret has been infringed, and to this end, he has to disclose his secret to the court, and that's a problem also to the parties of the lawsuit, meaning the defendant as well. So the dilemma is he either discloses his secret or he loses the case. And so far on the old law in Germany, there was no such thing as a protective order, which obligates all parties involved to keep an obtained information secret and forbids to use it. This has changed now. So we have now in the law, a new law, section 16, and this allows the court upon request to classify information as confidential. And this may be ordered before the legal service of the court action actually takes place. So, to obtain this, the applicant has to provide prima facie evidence that the information at hand is a secret. The consequence of this protective order is that all persons involved, including court clerks and staff, etc., must keep the information confidential. This duty of confidentiality applies as long as the information is secret, even after the trial has ended. Provided, however, that the information in question does not turn out to be no secret at all or ceases being a secret. And violations can be punished by monetary fines or even imprisonment. The first draft of the European Union directive still provided for the possibility that a party to the dispute might be completely excluded from oral proceedings or from access to certain documents, and that only their representatives would be admitted. So a confidentiality club. But neither the finally adopted version of the European directive nor the German Trade Secret Act permit such a strict confidentiality club. However, pursuant to Section 19 of the German Trade Secret Act, the court may now order that at least the number of persons who get access to documents and the oral hearing proceedings and hearings be limited to at least one natural person. Besides the legal counsel or other representatives. So one legal person, one individual of each party has to have full and complete access. So, and this, which is very interesting, these new procedural confidentiality measures shall not only apply in trade secret matters, but also just recently, the German lawmaker enlarged it, and now those measures are also applicable in patent infringement cases. And we are very curious to see whether this development will continue, and that we may maybe see in the future that also in trademark cases or copyright cases, etc., those measures will be available.
Axel, may I jump in just
yeah, no, it's up to you again.
No, so sorry. No, I just wanted to complement that and say, so just in practical terms, in the beginning, the courts were a little bit hesitant with applying these, and they didn't really know how it works. How should they word an order, and it was all new for them. But now our impression is that they are relatively relaxed, and that they are, well, basically there are no strict requirements, and they do order these things. So that's something that really works in practice now, which is very helpful. Okay, so let's go to the next slide, which is about the enforcement in practice and the interplay of civil litigation and criminal investigation. So just the next slide. So it's a yellow one. Or anyway, so the first question is, why is criminal law investigation in fact needed? I mentioned that before. The collecting of evidence is very, very difficult. It's not like in a patent case, you see a product and you can just analyze it and then you know, okay, there's patent infringement. Secret information usually stays in the factory or stays in the company of your opponent. So you don't see how it's actually used. You just have a suspicion. And in order to find sufficient legal evidence, the civil law remedies are just not sufficient. And that's why you need another means of getting this information, and that's a criminal law investigation. And some of the major German prosecutors, they actually understand their, well, one of them just told me, and he said, you know, my position, I understand my position as someone who helps you in getting this evidence in order to use it in a civil law case. It's not about really bringing the culprit to court and get a criminal sanction against him. It's about getting evidence. That's very important. Well, that's the one thing. And the second thing is, it's extremely complicated to synchronize civil litigation and criminal law investigation, because the civil law and the criminal law systems, they are not really well attached to each other, or they are not really, they don't really work well together. So you need to be very, very diligent and be on the phone with the judges and prosecutors all time in order to really synchronize what's happening here, what's happening there, what needs to happen first, and what needs to happen second. So that's very important. So the bottom line is that trade secrets litigation is not only about knowing the law, it's about a lot about just managing how the prosecutor, the judges, and the lawyers and so on work together in order to get the case going. And then that also applies to the making use of the results of a criminal law investigation. There's no real law saying how it can be used, and we developed, I think, an interesting way to introduce results of a criminal law investigation into a civil law case by getting a civil law judge ordering that the access to such information must be granted. So that's something new, and recently it worked out well with some prosecutors in several authorities in Germany. So that's about difficulties in practical enforcement. And then there's a last slide, and then you're and you're through. And the last slide is about cross-border cases. So that's an interesting thing, because German law says, and yeah, it used to say, and it still says, that as long as a damage occurs in Germany to a German company or to a company abroad which has a German subsidiary, then German law is applicable. So the same applies now. So in a cross-border case, whenever there is a German angle or an angle concerning another European country, even though one party may be from Brazil or any other place in the world, there could be a venue, there could be a damage, there could be German and European law applicable. I think that's important to know. You never really know in the beginning. You first have to analyze the case. You first have to get the evidence in order to find out where actually there is a venue and which law is applicable. But there's a good chance that if anything happens in Europe, you can have a case here too. I don't want to, Axel, I don't know.
Yeah, looking at, we are.
Because I just have
we
2 minutes.
exceeded our time limit already.
Well,
so thank you very much for your attention.
do you want to make a final remark, or are you good for the moment?
If you switch the slide, then we have some takeaway points.
Maria Fernanda, se você puder passar para o último slide, por favor.
Yeah, maybe one could say that trade secret litigation and enforcement of litigation in Europe, also with regards to also on an international level, has become easier because we have the new law, but at the same time it's a very complex matter. Then there are some things which companies really have to think about, and the most important thing is probably the thing about reasonable confidentiality measures. It doesn't work. Nothing works without those measures, and that's the first thing. And you have to put them into practice now, and you have to keep them up and everything. So that's basically on the to-do points. Axel, I don't know whether
I think given the time, I think we wrap up and leave some time for Ryan. And thank you very much for your attention. And if any other question pops up, just drop us an email, give us a call. We would love to answer your questions. Thank you very much for your attention.
Thank you, Axel. Thank you, Daniel. Actually, we still have, let's say, about 25-30 minutes. So we are good on time. So thank you so much for the excellent presentation. It covered very interesting aspects of the new legislation. I'm sure we will have questions in the end. And now moving on to you, Ryan, please. Yes, you may take over.
All right, thank you, Felipe. Can we get my slides up, please, as well? And I think we can jump right to slide number 4. Perfect, thank you. So just a brief overview of trades. I'd like to say as a threshold, thank you all for having me here. It's an honor to be here presenting to you. I appreciate the invitation, Felipe and Márcio. It's been a pleasure. So yeah, I was asked to give a brief overview of United States law as it pertains to trade secret protections. And historically, and by historically I mean prior to 2016, we had a very messy framework here in the United States. So here in the States, we operate under a constitutional system that outlines what our federal government can and cannot do. And part of our Constitution is that any power that isn't specifically delegated to the federal government is reserved to the states, which we have 50 of them, and they're the largest discrete units underneath the federal government. So we have a federal government under our Constitution that can only legislate on certain subjects, and when the feds can't legislate, the states fill in the gap. So prior to 2016 in the United States, we didn't have any sort of federal framework for trade secret protection. So each individual state came up with their own laws. And the only reason it wasn't more of a mess is because we have a real tendency to use something we call model statutes, which is, a think tank or some third party develops a statute, a template essentially, that is then used by the state. So almost every state used this template called the Uniform Trade Secrets Act, which was just like draft legislation, giving them somewhere to start from. But almost every state modified the UTSA, that model legislation. Almost every state modified it in some way. So despite the word uniform, 48 states had trade secret laws prior to 2016, and all 48 were slightly different. There would be slightly different statutes of limitations, slightly different remedies, slightly different redress. Just sort of a chaotic patchwork of ideas for this really important topic, because U.S. companies annually suffer billions of dollars in losses due to trade secret theft by their own employees, by corporate competitors, and even by foreign governments. So stealing trade secrets has increasingly become really important to our industrial sector and our manufacturing sector. Until 5 years ago or 6 years ago, we didn't have anything federally to say about it. Can I get the next slide, please?
Maria Fernanda, por favor, se você puder passar para o próximo. Obrigado.
Obrigado. So in 2016, our federal government introduced the Defend Trade Secrets Act, which I will be abbreviating DTSA. The three key goals of the DTSA were to create a federal civil remedy, bringing trade secret owners the right to bringing their rights into alignment with the rights that other IP holders, intellectual property holders, have traditionally held. In the United States, you can sue to protect a patent, you can sue to protect a trademark. You couldn't sue federally prior to 2016 to protect your trade secrets. So this passed through our government by overwhelming majorities. It was unanimous in one of our houses of Congress. It passed by a vote of 410 to 2 in the most contentious of our two legislative bodies. Was signed by President Obama with no hesitation. And the DTSA went into effect on May 12, 2016. A huge reason this was passed into law in 2016 is because Congress had a lot of anxiety about Chinese, in particular, corporate espionage, whether real or imagined, that was going on and costing American corporations money. So, on paper, ostensibly, one of the motivations for the DTSA was to combat foreign trade secret theft. In reality, we'll talk a lot, since what we're doing here in part as Brazil, contemplating what works and what doesn't work, and how you might apply this to your own laws. There's a lot of holes in the DTSA. It doesn't really do a lot of what it's intended to do, and we'll talk about why. For one thing, it does almost nothing to prevent foreign actors from doing anything at all to us. That's just not what it's actually about. Another problem we're having with the DTSA is that it's being interpreted, and I'll get into this a little more later. The law is interpreted by federal courts around the country. So we have federal courts in all 50 states, and it's not like they all sit in our capital and enforce federal law. We have a federal court here where I sit in Grand Rapids, Michigan. There's a federal court in Sacramento, California. They're peppered all over the cases, and these federal courts hear federal cases, but when they hear them, they apply state law. And we'll talk in a minute about how that's sort of gumming up how we apply this federal law, because these federal judges are applying the law of the state they're sitting in. But regardless, some courts, including one in Illinois, have held that the DTSA has extraterritorial effect outside of the country, meaning that Americans can use this law to sue foreign nationals. I haven't found a lot of examples of that actually working particularly well. Can I have the next slide, please, Maria Fernanda? Thank you. So one of the problems with the DTSA and its attempt to create this cohesive federal framework is that Congress explicitly did not preempt state law. So these were some of the compromises that were made to get this law passed by this massive margin. The reason it could pass 410-2 is because there's nothing really controversial in it. Congress did not do away with the state laws that already deal with trade secrets. So that old patchwork still exists and is still used quite a bit. So insofar as the DTSA was intended to establish this uniform national law of trade secrets, it doesn't really do that, because it just layers a new federal law on top of the state laws we're already dealing with. Substantively, the DTSA does mostly track the Uniform Trade Secret Act, which is the act that the individual states use. But it's also introduced an element of gamesmanship into trade secret laws, because sometimes plaintiffs now look at cases and realize, oh, I have an advantage under the federal law that I wouldn't have had in my state. So they're choosing forums and they're gaming where to file things, and it's created a number of unintended consequences for how we apply trade secret law in our country. Can we have the next slide, please? Thank you kindly. So what's notable about the DTSA? One of the most notable things is how popular it was, how uncontroversial it was, and concomitantly how weak it is, because it doesn't really have a lot of teeth beyond what was already out there. I'm not sure how many of you follow American politics, but imagining a bill this large being passed by a vote of 410-2 today is seems almost like a fantasy. It's hard to believe this was only 6 years ago. But again, the reason this happened is because many choices were made to facilitate how quickly it could be passed. Next slide, please, Maria Fernanda. So generally speaking, in U.S. law, what is a trade secret? And this is the general definition, not the specific definition under the DTSA. It's more what a trade secret is in our law is a little controversial. The restatement of torts, which is like a foundational a legal handbook that we use as lawyers in America, has a line in it that says an exact definition of a trade secret is not possible. I'm not sure that's accurate, but the definition we use for years and more or less agreed on in the United States is that a trade secret is a confidential, commercially valuable piece of information providing a company with a competitive advantage, such as customer lists, methods of production, marketing strategies, pricing information, chemical formulae, that kind of things. So well-known examples of American trade secrets, formula for Coca-Cola, recipe for Kentucky Fried Chicken, etc. Things like that were protected under the state laws and are now protected under the DTSA. Next slide, please. What isn't a trade secret are patents, trademarks, copyrights. We have an entirely separate branch of law. I'm a little low on time, so I'm not going to dwell on that too much. Maria Fernanda, can we move 2 slides forward? Obrigado. Okay. So the DTSA, what does it actually do? It allows plaintiffs to bring an action for any trade secret that relates to a product or service used in or intended for use in interstate or foreign commerce. That applies to virtually all trade secret plaintiffs these days. So two of the key terms that need to be defined to understand our rights under the DTSA, I don't know why I'm highlighting it on my screen, you can't see that, are what is a trade secret and what is misappropriation. Next slide, please.
Maria Fernanda, por favor. Obrigado.
Obrigado. We're on misappropriation. Okay, defining misappropriation. It's a tort. It's a civil crime that can occur in several different ways. Usually, it happens when an individual leaves a company and takes something with them they shouldn't have taken through theft, bribery, misrepresentation, what have you. Sometimes we have a doctrine where if an employee is sufficiently advanced, has sufficient knowledge when they leave company A and go to company B, it's considered inevitable that they'll utilize the trade secrets they've learned while working for company A, at least in some states. So misappropriation can occur in many different ways, but it essentially means the taking of a trade secret that isn't yours by improper means or without express or implied consent, or that person who took it had a duty not to take it. Next slide, please, Maria Fernanda. And to define trade secrets, the DTSA, Maria Fernanda, can we get the next slide, please? Thank you kindly. The DTSA specifically defines trade secrets as all forms and types of financial, business, scientific, technical, economic, or engineering information, whether tangible or not, irregardless of how it's stored, whether it's memorialized physically, electronically, graphically, photographically, in writing. It's a very broad definition. This is intended to be a broad act that provides a lot of protection for various trade secrets in the country. Courts, when applying the DTSA, have generally required plaintiffs to allege 3 elements to bring a successful claim. 1 is that a trade secret exists. 2 is that the trade secret is related to interstate or foreign commerce. And 3 is that that trade secret has been misappropriated. Maria Fernanda, can I have the next slide, please? So, yeah, a note just about federalism and why we have that requirement. There's a strange seeming requirement in our DTSA that says that it has to be a trade secret that affects interstate commerce. Like I talked about at the beginning, our federal government has limited jurisdiction and can't just make statutes about things that it wants to legislate on. So in this case, we have something in our Constitution called the Commerce Clause, which says that our federal government can pass laws as long as those laws somehow touch or affect interstate commerce, meaning trade between the states or trade with other countries. So under the DTSA, if a trade secret affects something that somehow affects interstate commerce, you can bring a complaint. It's difficult for me to imagine how any product would not affect interstate commerce in some way. It would have to be something that's sold exclusively within the state of Michigan, never leaves the state of Michigan, and then I guess there could be an argument that it doesn't touch interstate commerce. But almost every plaintiff will be able to clear that hurdle and say that the trade secret in question affects interstate commerce. Can I have the next slide, please, Maria Fernanda? So the remedies that are available under the DTSA, the primary two that are used are injunctive relief and damages. Injunctive relief is when a court will order parties to say you can't use that secret anymore. Damages, of course, are money. One thing that the case law regarding the DTSA has really gone into a lot of detail on and tried to flesh out in the various courts across the country is how do we prove damages for misappropriation? And we had a good case a couple years ago out of the federal circuit called Texas Advanced Optronic Solutions versus REA. And in that case, what the court held essentially, and I'm gonna condense this a little bit. What the court held there was that there needs to be a clear, what's the term they used? There needs to be a sufficient link between the misappropriated trade secrets and the damages award. In that case, what the court below had done that was being appealed from is assume that all of REA's profits came from the stolen trade secret. That doesn't make any, I mean, the stolen trade secret here was the design of a light sensor. That's not the only thing these companies do. So saying that all of REA's profits are from this stolen light sensor design doesn't make any sense. There needs to be a causal link between the stolen trade secrets and the monetary damages. Can I get the next slide, please? Maria Fernanda, can I get the next slide, please? Obrigado. So one of the most unique remedies under our DTSA is this idea of ex parte civil seizures, which is something that I have not been able to find in any other state or federal law in our country. What ex parte civil seizures do, what that means is you can take a motion to a court and ask the court to bring the sheriffs and seize property you're alleging is stolen without the court even hearing the other guy's argument. It seems fundamentally unjust in many ways, and this is only used in extremely extraordinary circumstances. To benefit from this from this power to be able to seize stolen trade secrets in the defendant's possession without a hearing, you need to show immediate and irreparable injury that cannot be remedied without seizing the property. You need to show that they actually possess a trade secret and property that is seizable. You need to provide the court with a detailed description of the property to be seized as well as its location. And you need to make some sort of allegation that if this ex parte seizure isn't made, your trade secret will somehow be destroyed. So it's a very difficult hurdle to clear. Generally speaking, courts hate this and will not actually use it. I did some noodling around this morning trying to figure out how often this has been used. I came up with about 20 to 25-ish. It's hard to get an exact count because there's so many federal courts. This has been, in the last 6 years, this has been attempted to be used about 25 times, I would say. 10 of those were granted. So this is not something our courts are using, but it is a very powerful tool now for American companies when they feel that a valuable trade secret has been stolen. And one of the most interesting things in the DTSA. I was listening along to our German friends explaining how the law works in the EU, and it's very similar. You know, the framework is fundamentally very similar, I would say, between the States and Europe, but I don't think this insane thing is actually in most other countries. Maria Fernanda, can I get the next slide, please? One of the other things that the DTSA does is provide whistleblower immunity. So sometimes we have a problem sometimes when a company is breaking the law, an employee will take something and try to report that to the federal government, and that could, through an uncharitable lens, be viewed as the theft of a trade secret. The DTSA explicitly says anybody who takes something to a government agency for the purpose of reporting a crime, bringing some sort of wrongdoing to light, they are protected under this law. So that is a valuable sort of with an eye to the public service, a we want whistleblowers to come forward. We want to encourage them to report crimes in their companies. We want them to know they have protections should they bring trade secrets to the government in an attempt to get their employer prosecuted. So that is out there as well. Maria Fernanda, can I get that last slide, please? So under the thank you very much. Under the DTSA, companies can still lose their trade secrets, and it's going to happen very much the same way. I saw it on their slide. I can't remember if Axel and Daniel talked about it, but it's very similar. It's if you have to protect your trade secrets, you have to take reasonable measures to secure confidentiality, to make sure your trade secrets aren't available on more than a need-to-know basis. You have to do the basic steps to make it clear to the world that these are protected trade secrets, or courts will not use either state or federal trade secrets laws to protect you. And this is where I think it's a good point to talk about one of the biggest failings of the DTSA. I don't know if this will affect you in Brazil because I don't really know how your system works. But as I mentioned before, we have federal courts applying federal law, but it's not a unified process. So every state has at least one federal court. I sit in the state of Michigan, which is not one of the biggest states in the union. We have two federal courts, one for the west side of the state and one for the east side of the state. Theoretically, both of those courts, because they're located in Michigan, should be interpreting the DTSA using Michigan law. But as I mentioned early on, some states have different laws. So we have this concept in trade secrets jurisprudence in the United States called inevitable disclosure. And the idea there is, let's say I run a company that makes widgets. My widget company has a director of product development who leaves me, very high level guy, leaves me and goes to work for widget company X. I want to argue as his former employer that it's going to be inevitable that he's going to use trade secrets he got from me when he goes to widget company X because of his depth and breadth of knowledge. And in many states you can do that. You can make that argument. It's called inevitable disclosure. So under the DTSA, theoretically, the inevitable disclosure doctrine should apply. But we're already seeing conflicting law arising out of that because we've got a state here called California. It's a very liberal state out to the west. In California, they hate the inevitable disclosure doctrine. They do not allow it. So when federal courts sitting in California have applied the DTSA, looking at California law, those federal courts say there's no inevitable disclosure doctrine. Meanwhile, here in the Midwest where I am, it's a lot less liberal. Our federal courts look at the DTSA, they look at inevitable disclosure and say, yes, absolutely, there is an inevitable disclosure problem here. So we've got courts applying the same law in different ways just based on what state the federal court is in. And there's no really easy way to resolve that until this gets to our Supreme Court, which could take a decade, because the Court of Appeals that sits over California and the Court of Appeals that sits over Michigan and Illinois, those are different court. Well, Michigan and Illinois aren't under the same Court of Appeals, but you take my meaning. These are different appellate courts even that will review the decisions these lower courts are making. So in short, the DTSA has a lot of great ideas in it, but you may want to look elsewhere when Brazil is considering how to model its law, because it's still young. It's still going to be developed by case law over the next decade or so, but it's already showing the need for some revision and maybe some rethought 6 years in. So thank you all very much for your time. I'm happy to answer any questions if there are any.
You want to, Márcio, do you want to take over?
No, please, you can start the comments.
Yeah, I'll just thank you so much again, Rayan, for the brilliant overview, very comprehensive. I do have a few questions, Márcio probably the same. We now move to our discussion or to the questions from the audience. I'm not sure if anyone from the audience has questions, but feel free to write it down in the chat, and then we can read it. Otherwise, yeah, you want to say?
Yes, just explain it in the meantime that this black label in the PowerPoint presentations was a way to show how to redact a confidentiality data in some presentations. So maybe the best way to keep a secret is to redact it and not show it to anyone, because our courts seems to have the same problems as in Germany and United States, whether in Michigan or in California.
Very good remark. Well, so I do have a few questions to raise. What about you, Márcio? Do you want to start with the questions, and then I can raise my questions after you? So
yeah, I was just first for Mr. Rayan. It seems that any case involving a Brazilian company would somehow relate to foreign commerce. So we could argue that in all cases the DTSA would apply.
The DTSA would apply only to protect the American company from the Brazilian company, so it can't work the other way, sadly. Well, or not sadly, depending on your point of view, I guess.
But maybe if the Brazilian company has a subsidiary in the United States, then it would apply, because this subsidiary would be an American company.
If it's an American company, it should be able to benefit from the DTSA, yeah. So if it's incorporated in America, I would imagine so, yeah. So it is a powerful law despite its many flaws. So there are definitely some. I could go on for hours about, because the other thing about the DTSA is it has very specific things companies have to do to avail themselves of the protections. You have to jump through hoops A, B, C, D, and E if you want the protections at the end of the day. So yeah. You would definitely want to consult with an American lawyer before trying to take advantage of the act, to make sure you're not stepping in a
yes.
puddle there.
Yes, thank you.
yes, I have a question to you, Ryan, as well. And now that we have, or that you have, a federal law, are companies more willing to go to court to litigate, or is there any official data showing a litigation increase?
Yes, we've seen obviously any DTSA case is new because it's new to federal. You could get into, I should say, I had this on a slide, but I skipped over it. You could theoretically get into federal law on a trade secret case prior to 2016. You could get into federal court based on something we call diversity jurisdiction, which is a whole concept I don't need to get into. But so there were a very small number of trade secret cases in federal court prior to 2016. Post 2016, we've seen, I wonder if I have the exact stats here. We've seen that jump a lot. We've seen, I believe the number was something like, when you consider state and federal trade secret cases aggregated, you know, because the state cases are still there. We've seen a slight drop in state cases and a huge jump in federal cases, so we're looking at about a 30%-ish increase in trade secret cases since the DTSA was passed, in large part because federal courts are much easier to deal with over here, so a lot of people would just rather bring their claim in a federal court.
Okay, great. We have here a question from the audience. Can you read it in the chat, Ryan, and can you see it, Daniel and Axel? If not, I can read it loud.
You can see it. I think it's about liquidated damages clause.
Yes.
Right? Yeah.
Yes. So who wants to start with
Yes, maybe before starting, this is something actually very common here in Brazil when we are negotiating NDAs or any types of agreements involving confidential information. Is to propose to use liquidated damages before for defining the damages before actually transmitting information. So is this really useful in your experience in the United States and in Germany or Europe?
Well, maybe I can say something about this. So I don't think that liquidated damages are that common in Germany. We rather use maybe a similar concept of contractual penalty clauses. So it's basically, it's similar. If there's a breach of the NDA, you have to pay a certain amount, and that's it. And that's something which we believe is important as a reasonable confidentiality measure, because you can have an NDA in place, but if you cannot really enforce it, and if it doesn't hurt the other party, if they breach it, then what's the use of it? And that's why we regularly tell our clients, yes, please include, if possible, include such a clause in the NDA or whatever kind of agreement which contains a confidentiality clause. And that will be valid. So there has been some case law, some discussions about validity, when is a clause valid or not. The employment courts are a little bit reluctant to accept very broad clauses because, I don't know, they're always employee friendly. But in principle, yes, such a clause is possible and valid.
And I may add that it's also very recommendable because the damages under the statute in case of an infringement are not even close to what I assume what you could get in the United States, for example. So in Germany, it's merely the real damage that occurred to you, and which many times happens to be less than the plaintiff originally thought and or hoped for. So having such a liquidated damages clause or a penalty fine in your contract, which would make your life much easier in order to get a reasonable damage.
In the States, we do use liquidated damages clauses, but they're kind of frowned upon in employment agreements. They will be enforced, I think, sometimes when there's malice or specific intent to do something wrong on the employee's part, but courts don't like enforcing liquidated damages clause against employees. So we still put them in contracts sometimes, but it's more bark than bite.
Very good. Márcio, would you want to add one more question, or should I raise one of mine?
Yeah, you can raise it, please.
Yeah, okay, perfect. So Rayan mentioned several flaws or some flaws in the DTSA. And actually my question is to Daniel and Axel. In your view, sorry, Rayan, in your view, the trademark directive, does it have flaws? Is there still room for improvement in the new legislation? So what would be your opinion on that?
If you write a book about something like this, you find a lot of flaws, I can tell you.
But I mean, what would be in your view the main points to be improved?
You know, I think the Trade Secrets Directive is fine. So a directive is basically thought to give the general framework. It doesn't need to be very exact in all aspects and so on. But the transposition into German law, it's not really well done. One of the issues is that well, some things it's a lot of technical issues in the law. It's not one of the more general points is that the new German Trade Secrets Act does not have a claim for inspection of sites. We have this claim in all other intellectual property laws. So if there is a suspicion of infringement, you can ask for a court order. The judge says, okay, go there with an expert, check it out, and so on. And then you get the evidence. There's no such rule in the German Trade Secrets Act, which is, I don't know why they didn't do that. And which is one of the reasons why we need the prosecutor to help with that. There are ways to do it, but that's obviously a flaw. And there are some others like, for instance, trade secrets should be protected not only in cases about trade secrets, but also in cases about, I don't know, trademarks, about patents. They did that now, about whatever. And the lawmakers just didn't think about that.
Everywhere, yeah. It should apply in every possibly apply or possibly applicable in all civil litigation cases. And I would like to add only one point, but as Daniel said, there are in fact quite some flaws in the German law. But one thing is really, I would already say it's annoying, is that at least for cases which take place merely in Germany, the lawmaker includes venue at the place, at the residence the defendant. And I mean, this is completely contrary to our tradition in intellectual property, and also the decades before in unfair competition law. This has changed now a bit in unfair competition law as well, but this really causes problems, a lot of problems, because in many cases now courts have jurisdiction which have never seen a trade secret case before. They have no experiences whatsoever in technical in technical areas, and in many cases the trade secret cases have very deep technical or very complex technical questions, and that makes litigation enforcement sometimes very difficult.
Yeah, they do have to say that the lawmaker they have a rule. The states, the 16 German federal states, they have the option to pick or select certain courts I don't know, to focus the litigation there, like we have it in patent cases that we have, I think it's 12 courts in Germany. Some of the states have done so. So Bavaria has done so, and Hesse, I think, but that's it. But now, otherwise, you get to know courts you would never have been to in your life. And it's even so crazy that if two companies are in a litigation about one trade secret, and the one party says, okay, I sue you, and the other says, I counterclaim, the counterclaim has to be brought to the other court, to the court of the claimant, and the first claim has to brought, you don't have jurisdiction in one court, but in two different courts. That's really crazy.
Okay, thank you, Daniel. I have another question actually, but Márcio, would you like to add any comment or?
No, you can move on.
Yeah, because you, Axel and Daniel, you mentioned that there's no recent case law regarding the criteria for damages calculation, if I understood correctly. Does the German law have any orientation in this regard, or is it yes?
So, I mean, we have quite some case law.
You do have. Okay.
We have some case law on damage calculation in other intellectual property fields, and it's very likely and yeah, it's very likely that those cases and the experience that we made in patent law, for example, will also apply.
Yeah, basically that
mutandis, yeah.
Basically, that's what the law says. So you have the principles of license analogy and so on. That's similar as in other fields of intellectual property law. What I was mentioning was that there is a difference. There's one different scenario. If you compare it to a patent case, you're always talking about what to pay for the use of a patent. It's always about using the patent technology. But in trade secrets cases, there is a difference. There's also a different scenario, namely the scenario of an unlawful disclosure, which leads to the trade secret becoming public. This is not, we don't have it in patent law, we don't have it in trademark law. So what's the value of it? Basically, the question is, you lose the trade secret because someone makes it public. So what's the value of the trade secret? And there's no case law about that. That's what I meant.
I understand. Thank you, Daniel.
Maybe something that they have to write a second book with 600 pages to explain. Yeah.
And I would have the same question, sorry, to you, Rayan, how the federal courts have been applying the criteria.
It's been very mixed. We've seen we've got that one really good case out of the Federal Circuit that deals with how to apply damages, but even the guidance of that case wasn't universal, and the Federal Circuit doesn't have jurisdiction over all the courts in the country, so it's not even precedential for example, federal courts in my state. So it's I would say our law is so young, it's still up in the air how it's going to be interpreted, applied, how damages awards are going to work. It's still all being developed.
Okay, thanks. Understood. So
yes, I think we are already close to the end, so maybe we can leave some time for final remarks from the speakers.
Yeah. Sure. Rayan, Axel, Daniel, do you want to have final remarks?
The famous last words. Well, I would only left for me is to say give a big thank you and to you, and I do believe that that some parts of the European directive, as Daniel said, could be a role model, but certainly not all of it. And it has to be, I think you should pick the best of the two or all trade secret worlds, and yeah, to get a decent new new trade secret law in Brazil.
Yeah, and I may add also a big thank you, and do not forget about well, the issue is probably not the substantive law. The most important thing is to give the means to the trade secrets owner to really enforce it. And that's something which is not very well done in the German system. So you should focus on this, how to get the evidence and all these things.
I will echo my thanks to all of you for letting us be here. I would say my comments would be similar to Axel's. There are definitely good things in the DTSA that I think Brazil could model on. I think the whistleblower protections we have in that law are a really good thing, really socially valuable. I wouldn't recommend copying our ex parte civil seizure thing, but you know, there's good elements out there. So I hope you guys are able to cherry pick the good ones and build something functional that protects trade secret owners.
Thank you so much, Rayan. Thank you so much, Daniel, Axel. It was great to have you here. Brilliant presentations, very comprehensive overview. I'm pretty sure we have learned a lot with you today. Thank you so much. Márcio, do you want to add a final remark?
Yes, thank you, Felipe. Thank you very much, Axel, Rayan, and Daniel. It was very helpful for us. I'm pretty sure that we will have take this opportunity for further studies in our association. We had more than 50 people at some moments here watching us, and I know that people will watch again, and others who are not available to be here right now from the association. And I already invite you all to be part of our Congress, which will happen in August. And so thank you very much again for your participation in the panel.
Yes, Brazil, as we know, has a long path to be in alignment with this international effort regarding trade secret protection. I'm sure we have learned a lot from you guys today, so thank you so much once again. And we need to finish our panel, sadly, so thank everyone for being here today. And thank you once again, Rayan, Axel, and Daniel. See you next time. Thank you.
Thank you.
Bye.
Bye-bye.
Thank you very much. Bye.
Em suas 39 primeiras edições, nosso congresso foi presencial, com grande sucesso. Veio a pandemia. O desafio de realizá-lo à distância mostrou-se uma oportunidade. Aprendemos a tirar partido da internet e repetimos o sucesso. Agora, para nossa imensa alegria, o pior da pandemia parece ter passado. Assim, podemos voltar a nos encontrar. E vamos comemorar isso no maior centro de negócios da América Latina, na cidade de São Paulo. De dura poesia concreta e discreta beleza. Do ano que se comemora o centenário da Semana de Arte Moderna de 1922. Frente a acontecimentos recentes no mundo das artes, como os NFTs, e frente à perspectiva de realidade virtual e a realidade aumentada virem a fundar uma nova internet, certamente teremos muito o que discutir. Como sempre, vamos tratar de todas as novidades no campo da propriedade industrial, pois sabemos que marcas, patentes e desenhos industriais ocupam um lugar de destaque no mundo em transformação. E vamos festejar a possibilidade de voltarmos a nos ver frente a frente. Depois da experiência remota bem-sucedida, quem, por qualquer motivo, não puder estar em São Paulo, não ficará excluído de nosso congresso e poderá interagir com os presentes. Todos poderão assistir a todas as sessões simultâneas no momento que convier, pois o Congresso Internacional da ABPI de 2022 será híbrido, como os novos tempos estão a permitir. E todas as sessões ficarão disponíveis na internet como desejam os nossos associados. É um novo desafio, mas estamos confiantes no sucesso. Afinal, São Paulo sempre foi palco de imensos desafios, da expansão de nosso território à independência, do sucesso de nossa indústria à grande revolução verde que impulsiona o Brasil e da afirmação de nossa cultura e nossas artes. A fronteira agora é no universo virtual e no ambiente de negócios que nele se constrói, totalmente dependente da melhor regulação possível da propriedade intelectual. Se preparem para as discussões instigantes do Congresso Internacional da Propriedade Intelectual da ABPI. Será uma grande confraternização. Não perca!